seated in the courtroom. Thank you. Good morning, members of the jury. We have finalized the charge of the court. I'm going to read it to you. You don't need to memorize anything. You will have a copy of it, and it'll be in the jury room during your deliberations to consult. After I complete my reading of the charge, both sides will argue the case, and then we will ask you to deliberate. This is cause number 25 FC 0001U. State of Texas versus Adrian Gonzales. Charge of the court, members of the jury. The defendant, Adrian Gonzales, is accused of 29 counts of endangering a child. The defendant has pleaded not guilty. You have heard all of the evidence that will be admitted as to whether the defendant has been proven to be guilty of these offenses in violation of the Texas Penal Code. Both sides will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether the defendant has been proven to be guilty or not. You will have a written copy of these instructions to take with you and to use during your deliberations. First, and I will note, ladies and gentlemen, the notes you've taken throughout the trial, the bailiff will hold those for you until after the deliberations are complete. As I told you, if we have a dispute as to anything regarding the evidence, we're going to rely on the official court record, so the notes will be retained during your deliberations. First, I will inform you of the general principles of law that must govern your decision in the case. Then I will inform you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles, the indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant may have been arrested, confined, or indicted, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The law does not require a defendant to prove his innocence or to produce any evidence at all unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt. After a careful and impartial consideration of all of the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish the guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If, after you have considered all of the evidence and these instructions, you have a reasonable doubt as to whether the defendant is guilty, you must find the defendant not guilty. Jury as the fact finder. As the jurors, you must review the evidence and determine the facts and what they prove. You judge the credibility of the witnesses and what weight to give their testimony. In judging the facts and the credibility of the witnesses, you must apply the law as provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only the evidence to reach your decision. You must not consider, discuss, nor mention anything that is not in evidence in the trial. You must not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by lawyers are not evidence. Evidence consists of the testimony of the witnesses, materials, and physical items that were admitted into evidence. Nothing the judge has said or done in this case should be considered by you as an opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are to be given special meanings. In that case, you should give those terms the meanings provided in these instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and the evidence that are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based upon the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice or sympathy. You are admitted exhibits. You will be provided all of the admitted exhibits for your examination in the jury room. Testimony, the court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson or presiding juror, number one, states that it has a disagreement about a specific statement of a witness or a particular point in dispute, and number two, identifies the name of the witness who made the statement. The verdict, the law requires that you must render a verdict of either guilty or not guilty. The verdict of not guilty simply means the state's evidence did not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on the verdict. When you reach a verdict, the foreman or presiding juror should notify the court. The defendant's right to remain silent. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf if he elects to do so. The defendant may also choose not to testify. The defendant's decision not to testify cannot and must not be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Instructions on count one, endangering a child. Excuse me. Accusation. The state accuses the defendant of having committed the offense of count one, endangering a child. Specifically, the accusation is that the defendant, as a peace officer for the Uvalde Consolidated Independent School District, by omission, intentionally, knowingly, recklessly, or with criminal negligence, placed Jose Manuel Flores, Jr., a child younger than 15 years of age, in imminent danger of death, serious bodily injury, or physical or mental impairment by engaging in one or more of the following omissions. A, after hearing gunshots and after being advised of the general location of the shooter by witness one, and having the time to respond to the shooter, the defendant failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, and delay the shooter, or failed to otherwise act in a way to impede the shooter until the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112. B, after hearing gunshots and after being advised of the general location of the shooter by witness one and having time to respond to the shooter, the defendant failed to follow his active shooter training to respond to gunfire by advancing toward the gunfire until after the active shooter shot at one and more than one child or children in rooms 111 and 112 of Robb Elementary School. And that as a peace officer for the Uvalde Consolidated Independent School District, the defendant had statutory duties to act as follows: to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater, or after being informed in any manner that a threat had been made by one person to do some injury to another person, to prevent the threatened injury if within his power, or to protect the safety and welfare of the people in the jurisdiction of his school district, and that the defendant did not voluntarily deliver to Jose Manuel Flores Jr. to a designated emergency infant care provider. Relevant statutes. A person commits the offense of endangering a child if he intentionally, knowingly, recklessly, or with criminal negligence by omission engages in conduct that places a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. A person commits an offense by omission only if the person has a duty to act. A peace officer has a duty, A, under the provisions of Article 6.06 of the Texas Code of Criminal Procedure, to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater. B, under the provisions of Article 6.05 of the Texas Code of Criminal Procedure, after being informed in any manner that a threat has been made by one person to do some injury to another person, to prevent the threatened injury if within his power. C, under Section 337.081 of the Texas Education Code, to protect the safety and welfare of people in his jurisdiction. Such endangerment is not an offense if the defendant voluntarily delivered the child to a designated emergency infant care provider under Section 262.302 of the Texas Family Code. Definitions: conduct, an act or omission and its accompanying mental state. Omission, a failure to act. A person commits an offense only if he voluntarily engages in conduct including an act, an omission, or possession. A person who omits to perform an act does not commit an offense under the law, unless a law provides that the omission is an offense or otherwise provides that he has a duty to perform the act. Intentional conduct, a person acts intentionally as required by this offense if the person has the conscious objective or desire to engage in the conduct that would place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. Knowing conduct. A person acts knowingly as required by this offense if the person was aware that his conduct was reasonably certain to place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. Reckless conduct. A person acts recklessly as required by this offense if there is a substantial and unjustifiable risk that his conduct would place a person younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the person's standpoint, and the person is aware of but consciously disregards that risk. Criminally negligent conduct. A person acts with criminal negligence as required by this offense if there is a substantial and unjustifiable risk that his conduct would place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the person's standpoint, and the person ought to be aware of that risk. Bodily injury means physical pain, illness, or any impairment of physical condition. Designated emergency infant care provider means an emergency medical services provider, a hospital, or a child placing agency licensed by the Department of Family and Protective Services that agrees to act as a designated emergency infant care provider and has on staff a person who is licensed as a registered nurse and who will examine and provide emergency medical services to a child taken into possession by the agency. Excuse me, sir. Application of the law to the facts. You must determine whether the state has proven beyond a reasonable doubt 6 elements. The elements are that number 1, the defendant in Uvalde County, Texas, on or about May 24th, 2022, engaged in one or more of the following omissions. A, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, or delay the shooter, or failed to otherwise act in a way to impede the shooter until after the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112, and or B, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to follow his active shooter training to respond to the gunfire by advancing toward the gunfire until after the active shooter shot at one and more than one child or children in rooms 111 of Robb Elementary School. And number 3, Jose Manuel Flores Jr. was at the time a child younger than 15 years of age. And number 4, the defendant acted intentionally, knowingly, recklessly, or with criminal negligence. And number 5, the defendant was a peace officer for the Uvalde Consolidated Independent School District and had a duty to act by virtue of the provisions of the endangering of a child statute and or other state statutes, providing that he had a duty to perform the said acts that he omitted to perform. And number 6, the defendant's conduct was not a voluntary delivery of Jose Manuel Flores Jr. to a designated emergency infant care provider. You must all unanimously agree on the elements listed above. If you agree the state has failed to prove beyond a reasonable doubt one or more of the elements listed above, you must find the defendant not guilty of count 1, endangering a child. If you agree the state has proven beyond a reasonable doubt each of the elements listed above, you must find the defendant guilty of count 1. Stipulation of facts by the parties. The defendant has stipulated that the named child victims in the indictment either suffered death or physical bodily injury on May 24th, 2022 as a result of the mass shooting at Robb Elementary School in Uvalde, Texas. All right, counts 2 through 29, ladies and gentlemen, instructions on those counts endangering a child. The state accuses the defendant of having committed the same offense of endangering a child in counts 2 through 29. Specifically, the accusations in these counts are the same as those in count 1, except that the alleged victims, all children younger than 15 years of age, are as follows. Count 2, Azucio Sergio Garcia. Count 3, Xavier James Lopez. Count 4, J.C. Carmelo Ivanos. Count 5, Annabelle Guadalupe Rodriguez. Count 6, Alexandria Anaya Rubio. Count 7, Leila Marie Salazar. Count 8, Elena Torres. Count 9, Rogelio Fernandez Torres. Count 10, Nevia Alicia Bravo. Count 11, Jacqueline Jaden Casares. Count 12, McKenna Lee Elrod. Count 13, Elena A. Garcia. Count 14, Tess Marie Mata. Count 15, Miranda Gail Mathis. Count 16, Alethea Haven Ramirez. Count 17, Maita Elena Rodriguez. Count 18, Jayla Nicole Silguero. Count 19, Ameria Joe Garza. Count 20, Noah Oscar Arona. Count 21, Chloe Melinda Torres. Count 22, Jordan Demetrio Olivares. Count 23, Jadian Canizales. Count 24, Samuel N. Salinas. Count 25, Kendall Faith Olivares. Count 26, Mia Sorillo. Count 27, Gilberto E. Mata. Count 28, A.J. Martinez. Count 29, Maya Zamora. Relevant statutes and definitions in regard to the above. The relevant statutes and definitions for counts 2 through 29 are the same as those that have been set forth previously in the instructions for count 1. Application of the law to the facts, you must determine whether the state has proven beyond a reasonable doubt the same 6 elements listed in count 1 previously with respect to each of the remaining counts 2 through 29, except that the names of the victims alleged in these counts are different. Likewise, you must all unanimously agree on all such elements with respect to the remaining counts 2 through 29. With respect to each of the remaining counts 2 through 29, if you all agree the state has failed to prove beyond a reasonable doubt one or more of the 6 elements, you must find the defendant not guilty of that particular count. However, if you all agree that the state has proven beyond a reasonable doubt each of those 6 elements, you must find the defendant guilty of that particular count. Rules which control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go to the jury room. Your first task will be to pick your foreperson or your presiding juror. The foreperson should conduct the deliberations in an orderly manner. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with the other members on the verdict, and sign the verdict sheets. While deliberating and until excused by the trial court, all jurors must follow these rules. Number 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. Number 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. Number 3, you must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. Number 4, you must not conduct any independent investigations, research, or experiments. Number 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter alone. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your verdict sign his or her name to the particular form that conforms to your unanimous verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Date, January 20th, 2026. Sid Harrell, judge presiding. Ladies and gentlemen, there are 29 verdict forms attached. They are all identical other than the name. I'm going to read the first form to you to illustrate what they all say, and the rest will be attached to the verdict for your consideration. Now, the verdict forms are not to suggest to you what your verdict should be. However, Should you decide to use these verdict forms, each and every one must be signed by the presiding juror, the foreperson, indicating your unanimous verdict. Count 1, verdict, not guilty. We, the jury, find the defendant, Adrian Gonzales, not guilty of count 1, endangering a child, as charged in the indictment, with a signature line for the foreperson and a line for the printed name of the foreperson. Verdict, guilty. We, the jury, find the defendant, Adrian Gonzales, guilty of count 1, endangering a child, as charged in the indictment. Again, signature line for the foreperson and a line for the printed name of the foreperson. Identical verdict forms for each of the 29 counts alleged. All right, ladies and gentlemen, at this time, both sides have an opportunity to argue the case. The state does have the burden of proof, so they have the opportunity to open and close the arguments. I will ask them to address you at this time.